Hey everybody, it's Guardian Mike here, and we have a new series. I call it Battle Series. These are tips and tricks that I experience in working with attorneys, and I'm looking for opportunity to share what I've witnessed, what I've experienced, to help you save attorney fees, to help you save costs and angst. So, what we have is we have quite a few people are children of second marriages, and that being the case, you're going to often experience your parent under guardianship in a marriage. You may or may not be in state. So, let's take the scary version. Mom or dad comes under guardianship. You're in another state. The court appoints a guardian and a conservator, a guardian of the person and of the estate, meaning of the money. So somebody is handling mom or dad's, one of your parents' affairs. You're not satisfied, but we have a guardianship and a conservator in place, one person in place. And let's pretend that the court appoints an attorney. So you're seeking to modify that. You want to be the guardian of your parent, and you feel you can do a better job. And because you're out of state, you don't know a whole lot about your parents' affairs. You want information. Now, and you want to take over from the attorney the guardianship aspect of the person, the guardianship, which is placement medical decisions. So you got that? Now, your parent has a spouse, and this spouse, for any number of reasons, may not be serving as guardian or conservator, but the court has appointed a neutral third party, which is an attorney, under these facts. So I'm going to underline that. And for lack of a better term, the eggs have already scrambled. There has been a hearing, a trial, and the court has determined that the spouse will not be guardian conservator. You will not be guardian conservator. But the neutral third person, a lawyer, is going to be guardian conservator. So it's, say, a month or two down, and you're not happy with that. Some might say you want a second bite at the apple. You didn't really understand what was going on, or you didn't have a chance to have your say. So you're going to go to war. You're going to go to court. You're going to challenge the status quo and say, listen, I know that we've had an appointment. I know that we've got an attorney involved, but I know that my parent has a spouse, but I'm a child and I want to have a say. In this process, and I want to bring this together, you're going to want information. How do you best get information? Now think about it. You've got some choices. You can go online, you can hire a private detective, you're represented by a lawyer. You can have that lawyer seek out information. And you have the fiduciary, which is the guardian conservator, which has a wealth of information and access to all of your parents' records. So as you're thinking this through, you sit down with your attorney. You have some options that you want to go over with your attorney. Do you seek independently to go to the bank to get information about banking records? Do you have your attorney request from your parent's spouse that information, and that your parent's spouse most likely will have a lawyer? So you've got your lawyer, your parent's spouse lawyer, and a third attorney is the fiduciary that the court's appointed. Or, so again, do you and your attorney go to the bank? You're not going to get any information. They'll probably stop you from getting it. Do you go to the bank and knock on the door and say, give me the last 5 years of my spouse, my mom or dad's records? Or do you go to the spouse and say, listen, you're married to my parent, give me the last 5 years of the records, or have your lawyer talk to their lawyer? There's a third option. Do you go to the fiduciary? I'm going to suggest you go to the fiduciary. Your lawyer write a letter and say one of two things. Hey, we'd like to get the records of Bank X. We'd like the last 5 years. Can you get those records, or will you give us a release so I can get them? Saves money. You can do an official discovery request through your lawyer and send it to the other lawyer. Now you got two lawyers, plus the lawyer that represents, that would be your lawyer, the lawyer that represents your parent, the lawyer that represents your parent's spouse, and now you've got a fourth lawyer who is the fiduciary. 4 lawyers are burning up attorney fees because you want information. Now think of the wisdom of that. Think about going to your lawyer and saying, hey, we've got someone here who has access to records. Can't we suggest in a letter, instead of doing formal discovery, interrogatories, depositions, and things, I just want A, B, and C. I want records. This is 90% of the request. They just want to know, did my parent move hundreds of thousands of dollars in the last 3 years to Canada or Bahamas or to the spouse, because I'd like to know that. And maybe I don't trust my parent's spouse. So what you want to do, your first door to knock on is the fiduciary, the guardian conservator, and say, listen, that's my parent that you're taking care of, and I'd like to know how you feel and what your policy is and what your opinion is on the court's policy of giving me a release to go down and get the records, or you go down and get the last 3 or 4 or 5 years records. Here's what they're going to say 9 times out of 10. Judges like to have a free exchange of information. Judges like to reduce attorney fees and costs. So the fiduciary could give you a release, or the fiduciary could say, listen, I'll get the records for you so I have some kind of semblance of control, but you have to pay. So I'll request bank records going back 5 years, but they're going to charge us, say, $100 for copy costs. You have to pay that. Or they'll say, no, I don't think I'm going to do that, but I think if you went to the court and asked the court, they would probably order me to do that. But I don't feel comfortable doing that because I got a big family here and they'll fight me. But you begin to look and see, and you can ask your lawyer, can you talk to the fiduciary, or can I go over there and make an appointment for a half hour and talk to them? And begin, as opposed to going to war, going to battle, and suing the spouse of your parent, saying, I want all these records, I want all this information. Do you really care what source it is that the records come from? Do you really care? Because you're going to inflame that situation. You're going to cause more problems, and probably the spouse, if the account is in your parent's name and you don't know it, could be, and it's not a joint account, they may not have access to that record. So they're going to have to, and if there's been an official formal request, and your lawyer may want to serve you well, and they have an official formal request for interrogatories, lots of state of court of this and that, all kinds of legal information that really looks impressive, 5 names on it, but it's costing you attorney fees, it's costing your parent attorney fees, it's costing everybody attorney fees. So why don't we reduce the cost of 5 attorneys to 1, go directly to the fiduciary? You got that? And you can put the request in writing. And you can say to your lawyer, look, I'd like to ask him questions. Now, if you tend to be like Jerry Springer, then he's not going to want you around that. You're going to do more damage. So we don't want a Jerry Springer result. But very simply, hey, I'd like to know the list of dad's bank accounts. Where did he bank at, if it's dad, spouse? And say, I'd like to get the records for the last 3 years. And, the fiduciary might say, great, here it is. Or the fiduciary may say, hey, listen, I'm going to call up your parent's spouse and see what they think. And most likely they're going to say, if they don't agree, the judge is going to order it. Something like that. So know about that. So what you want to do is, before you rush to judgment, rush to court, ask for tons of information in a formal request that has to be responded to and requires attorney time on the part of your parent's spouse. And people are talking together, trying to sort this out. Just go to fiduciary. Say to the guardian conservator, what can you do for me? When can you do it? Do we have to have a family meeting? Can't we talk about this? That's going to be, and if you do it and your lawyer lets you do it, you can say, listen, why can't I do this? Why can't I type up, here's the typed letter I'm going to send. I've got it here. I have a request. I'd like to get this information. I'm going to save attorney fees. I'm going to save costs. My attorney, I love you very much, but why can't I do this? And they're going to sign off. They're going to say it's okay. Send it, fax it, whatever you want. Have a family meeting. You're going to save money, big money, okay? And you're going to tend to mend fences and not have fights and judges like that. It's already difficult when you're dealing with a blended family and people are at fighting, okay? Costs you lots of money. You're going to have a money bank, a time bank, and an emotional bank, and they'll all be on empty when you're done, and 5 attorneys will walk away, okay? That's not what you want to do. Okay? There are alternatives. You got options. So my trick is, if you're represented by an attorney, write up something. Say, hey, I need 10 minutes on a phone call with you. I'm thinking about doing this. What do you think about it? Here it is. I want to go to the fiduciary. Fiduciary can authorize access to anything, right? Okay. Bank accounts is what we're talking about. If the joint returns are on taxes, they're joint returns, you get access to tax records. You got a lot of things to talk about, and you can do them yourself. If you're representing yourself, start with the fiduciary. Don't argue. Put your requests in a piece of paper. Don't do 4 volumes of Quo Vadis where you got 100 pages. And if I'm the fiduciary, I'm going to say, listen, I don't care how many pages you have, but I'm only going to read the first 25 words. Get your point across to me. So I want you to think about that. You're going to have a fiduciary that's going to want to read only 25 words. Get your points across. Hello, my name is Susie Smith. I want these bank records going back 5 years because I want to know what's going on. Because I might want to become the successor. Because I think I'm entitled to that. I mean, you don't necessarily have to have a lot of reasons, because there's a free flow of information here. In each state is different, each court is different, but you can make feelers, okay? You can just ask. And they're going to respond to your 25 words and say, no, yes, because, no, because. They'll let you know. Good fiduciaries want to resolve conflict early on. Excuse me. All right, leave your comments below. Don't forget to subscribe. If this is helpful, let me know. I'm going to just kind of on the roll here, on the fly, as I experience this. And I think, there's a better way to do this, a better way to do it. And so I share with you what I witnessed go on and how a better way there is to achieve the results of peace, harmony, moving away from war, keeping the lawyers from getting enriched and engorged on what you're doing there, so that there's a place for lawyers. I like lawyers. Great lawyers around. But you know what? If they're not needed, why stuff dollars in their pocket? Okay? And you can ask questions. Always good thing to do, to ask questions. All right? I hope that's helpful. I hope as I go along, one of the problems when we do this on the fly is I experience something. I get it down really quick. I don't have a script. I want these points that I have witnessed to come across, and I have witnessed unnecessary triple and quadruple and 5 times the fees that it's just not necessary. And if people just talk, if people knock on doors, the doors will open, and you don't have to do this. You might be able to avoid that. Very expensive. Not that's your goal. That's something else. But I'm talking to people that want to reduce attorney fees, want to know how to work with attorneys. So again, I'm going to summarize. How to work with attorneys. You're not represented, then you call the attorney who is the fiduciary. It's not the time to chit-chat. Not the time to, you say, I'm sending you an email or a fax with 4 points on it. This is it. And you can leave it with the secretary. You don't even have to talk to the lawyer. You're going to get better results. If you have a lawyer, you go to your lawyer first to say, listen, this is a fiduciary. I want some information. I'm thinking about doing this. I don't want to do an end run around you. I've got 4 points, very succinct, 1 page. It's done on a half a page, and I'm asking him to provide me with information, access to information, either releases or he gets it. And I'm willing to pay up to, I'm willing to pay up to $100. If the fee exceeds $100 when you request banks records from Chase Bank, bank records from Chemical Bank, then tell me ahead of time. Okay? Got that? You're going to save attorney fees. Your attorneys are going to like working with you. You're very focused and to the point. You're not doing any end runs. And you've got a very good fiduciary. Let's presume they're very good and they want to cooperate. And this is your first step. And then you go to court to later on, if everybody says, no, we're not going to do this, forget that, I don't want to talk with you, then you can think about going to court. And then you can lock down and you've documented, you've exhausted your remedies. 9 times out of 10, good people are going to share information, okay? Again, subscribe, like the video, give us comments below, let me know how I can help, okay? Thank you.